Good day, viewers. My name is Ejeh, a law graduate of Kogi State University and a virtual intern at HARLEM Solicitors. Today, I will be taking you on a critical appraisal of trademark laws vis-a-vis the first say doctrine, and we are going to be considering the case of Nike v. MSCHF. By the end of the day, you'll be able to understand what is trademark, what are the laws governing trademark, what is trademark infringement, what are the categories of trademark? What is the duration of trademark as long as the Federal Republic of Nigeria is concerned? I'm also going to be taking you through the first say doctrine, the exceptions to the first say doctrine, and we are going to be wrapping up by considering the case of Nike in MSCHF. Now, Nigeria has the largest economy as long as Africa is concerned, and Nigeria is the most populated country as long as Africa is concerned. Therefore, there is a serious need for protection of trademarks in Nigeria. By the provision of Section 67 of the Trademarks Act 2004, it defines a mark to include any device, brand, heading, label, ticket, word, number, name, or any combination thereof. The World Intellectual Property Organization (WIPO) defines a trademark as a sign that distinguishes the goods and services of one entity from those of other entities. Now, what are the laws governing trademark in Nigeria? The Trademark Act of 2004 is the principal legislation for trademark protection in Nigeria. But we have other laws also. We have the Trademark Regulation of 1990. We have the Merchandise Mark Act of 2004. We have the Trade Malpractices and Miscellaneous Offences Act of 2004. We have the Cyber Crimes Act of 2015. Now, by the provision of Section 45 of the Trademark Act, the Minister of Trade and Investment is empowered to make regulations with respect to the provisions of the Trademarks Act and also to enforce the provisions of the Trademark Act. What are the durations, or what is the duration of trademark in Nigeria? By the provision of Section 14 subsection 1 of the Trademarks Act and Section 23, the duration of trademark in Nigeria is for 7 years, but subsequent renewals will be for 14 years. Now, it is also important to note that application for registration of trademark can be done by the proprietors or through an agent. An agent can also make an application for the registration of trademark. What are the categories of trademark? We have a coined trademark, we have the arbitrary trademark, we have the suggestive trademark, we have the descriptive trademark, and we also have the generic trademark. Now, let's proceed to what is the first say doctrine. The first say doctrine presupposes that a reseller can sell a particular product without the consent of the original seller, provided that such resale will not mislead the public. Now, there are exceptions to the first say doctrine. The first exception is that when there is a material difference, the first say doctrine will not protect a reseller who sells a product that is materially different from that of the original seller or the owner or the holder of the trademark. Now, to establish this, the company must show that there is a difference between its own product and that of the product that has been sold by a reseller. To do this, it can be in form of a difference in promotional benefits, let's say in form of a warranty or a guarantee, or in form of something like a money bag. A company that provides a warranty for the purchase of their product, if another person resells that product with such warranty, it can be seen as a material difference. Secondly, when there is quality control in a particular product. Now, to establish this particular issue, the company must show that it has an established quality control that is legitimate, that is substantial, and that is non-protectual. Secondly, that he is abiding by that quality control. The company is abiding by such quality control. Then thirdly, that the seller or the reseller now is not abiding by such quality control and therefore misleading the public, the general public, with respect to the purchase of such product. Now, this particular exception was given a statutory backing in the Lanhams Act of 1946 by the provision of Section 32 and Section 43 of the Lanhams Act. Let's proceed to the case of Nike v. MSCHF. it is natural, of course, for a person to buy a shoe and resell it at a higher amount. There's nothing illegal about it, there's nothing unlawful about it. But where a person buys a particular shoe that belongs to a particular company, injects a drop of blood in the sole of that shoe, buys the shoe at 666 pairs, the number is 666 pairs, attach some demonic images, and also attach a pentagram to it, and with a write-up of 666, which is a sign of the coming of the Antichrist, and some other features, and call it the Satan's shoe, then the question will arise is how lawful is it? How lawful is it for a person to sell this product without the owner of the mark's consent? This was the case that was analyzed and dissected in the case of Nike v. MSCHF. MSCHF produced this shoe on the 29th of March 2021, and the shoe received a lot of public controversy. The modern change makers were actually happy with the shoe, while they traditionally saw it as a blow to ethical value in the society. Nick brought an action against MSCHF, claiming the following: that there was a trademark infringement, that there was a false misrepresentation of origin, that there was a trademark dilution, and that there was an unfair competition on the part of MSCHF. Now, MSCHF produced this shoe in collaboration with Lil Nas X's music video called Call Me By Your Name, where he was expressing his cheerful desire and joy in being a gay man. The shoe received a lot of criticism. Some social media, a particular social media, posted that I won't buy Nick's shoe again. People were actually desisting from buying Nick's product, buying even the original product, because of the production of the Satan's shoe. Nick brought this action, and the court held this case in favor of Nick. There was a ruling in favor of Nick, issuing an injunction on MSCHF to discontinue the production of such shoe, the marketing of such shoe, and so on and so forth. At the end of the day, on the 9th of April 2021, Nick and MSCHF came to some terms of settlement. One of it was that MSCHF was going to refund the purchase price to the buyers, including the shipping fees. MSCHF was going to recall the shoes from the market, and MSCHF was also going to discontinue further production of the shoes. At the end of this whole thing, it was established that, of course, in as much as the first say doctrine, which was established in 1908 in the case of Bob Mary Co. v. Truss, provides that a person can resell a product without the owner's consent. In a case where such resale is likely to mislead the public, which was obvious in that particular case, the law will come to the aid of the company to protect its goodwill and to protect its integrity. Now, in a nutshell, we have seen that trademarks, they are signs that differentiate the goods and services of one entity from that of other entities. And we have also seen that there are exceptions to this particular trademark protection, which is the first say doctrine. We have also seen that the first say doctrine has other exceptions, which include material difference and when there is a quality control. And we have also appreciated the case of Nike v. MSCHF. The case of Nike v. MSCHF brought to mind the fact that in as much as companies and brands are permitted to come up with new innovations that will lure the public into buying of their product, these innovations must be kept within ethical barriers, where religion, norms, values, public opinion of the public are not given consideration in the production of a particular product. The product will be rejected by the public and therefore will not be good for the goodwill of the company. For further information about intellectual property, copyright, trademark, you can visit our website at www.harlemsolicitors.com, or you can also check us on our social media handles at Harlem Solicitors. Thank you for watching this video.